Good morning, Intro to Law class. Again, I hope everybody's doing well out there, and I hope you're watching the movies we usually ask you to take a look at. I think they're very instructive and interesting and provide a good supplement to the class. Today what we're going to do is continue on with our discussion of criminal law. And there'll be one more lecture after this, and hopefully at that point we'll be able to finish off criminal law and start talking about the next area, which is, I believe, torts. And in talking about criminal law, what we did last time is we gave you an overview of crime in the United States, and then we talked about how do you process a criminal case. Today what we want to do is do analysis of substantive criminal law. So what are the major types of crimes? And within that context, what are the elements of a crime? So in other words, what do you have to prove in order to find someone guilty of that crime? Or to use another term, what's the cause of action? And in looking at these things and applying, we're going to talk about two major types of criminal categories. Crimes against the person, so against the person of the individual, and crimes against property. So let's start out by asking some very general questions about what's crime, what are types of crime, and what do we mean by elements of a crime. So what is a crime? Now, talking about what is a crime, the first thing we want to make sure you understand is that most wrongful behavior is categorized as private offenses between persons. And if it's a private offense against a person, then it's a civil action, not a criminal action. And the big distinction here between these criminal and civil actions is whether or not society is threatened. So if it's a civil action, you're basically arguing that, and it's solely a civil action, that society is not threatened. But certain wrongful behavior is so offensive that it does threaten the common good or the safety of a society. So a crime is a wrong against society. And by definition, such behavior is prohibited by statute. So you have criminal statutes that tell you what you can or can't do, a violation of which is the crime. And when we talk about crimes, we talk about two elements that generally exist in order for there to be a crime. The first is a specific state of mind, and we refer to that as mens rea. The second part is the performance of a particular prohibited act, and that's referred to as actus reus. So for most crimes, you need a particular state of mind, and that particular state of mind has to be a criminal state of mind, and what we'll show you is we define criminal state of minds in different ways. And then the performance of some kind of prohibited act, an act committed in violation of public law. Now, even if both of these things do exist, you're not necessarily automatically convicted of a crime. And the reason is there can be defenses to a criminal act. Defenses. And we'll talk about those. Now, when we talk about crimes, what we have to realize is that most crimes are also torts or civil actions. So the crime of burglary equals the civil action of trespass. The crime of murder equals the civil action of wrongful death. The crime of assault and battery equals the civil action of assault and battery. Now, not all crimes are the same. So we generally break crimes, society does, down into two types, felonies versus misdemeanors. And the distinction is based upon the severity of the criminal act. So felonies, for the most part, depending upon the state, are any kinds of criminal actions for which the penalty is imprisonment for 1 year or longer. And then a misdemeanor. So a misdemeanor is a wrongful action for which the penalty is less than being in prison for 1 year or longer. And it can also be a fine, as well as an incarceration. Now, as we said, there's two types of crime. There's crimes against the person and crimes against property. And what we want to start off with are crimes against the person. And we'll talk about the most serious crime against the person first, and that's murder. Murder. And when we look at the cause of action for murder, or the elements of the crime, murder has been defined as an unlawful killing with malice aforethought. And malice aforethought is the highest degree of mental culpability or blameworthiness. So in order to have malice aforethought, what you need is this idea of premeditation. It had to be premeditated. So premeditation is an important factor. Now, one of the things that we know about this idea of premeditation is different states define premeditation differently. So in some states like California, you have to show that there was an entire plan that was developed and thought through and debated and then implemented. In Pennsylvania, on the other hand, they say that premeditation, all it means is, did you have even a moment to reflect on your actions and understand that they were wrong? So different states have different approaches. So a murder is an unlawful killing. Now there's other types of unlawful killing. So for example, you have something called manslaughter. And manslaughter, in terms of the criteria for that, is an unlawful killing of a person under emotional circumstances. So for manslaughter, you need provocation. And then most states have subcategories of manslaughter, and the two major types are voluntary manslaughter and involuntary manslaughter. So on page 226 of your book, they define those terms for you. So voluntary manslaughter is the wrongful and intentional killing of another person during the heat of passion, or under the influence of alcohol or drugs, or while engaged in some reckless and dangerous activity. So for voluntary manslaughter, the key to understand here is that you have a situation where it is an intentional killing. So it's still an intentional killing, it's just an intentional killing under emotional circumstances. Now, involuntary manslaughter is a little bit different. Is the unintentional killing of another person because of gross negligence or as a result of dangerous and unlawful conduct. Now, why are these distinctions important? They all deal with someone being killed. Well, they're important because the penalties that can be imposed by the courts differ depending upon which of these you're convicted of. So they can be defined as lesser included offenses. Murder would have the serious penalty in every state, and then manslaughter would have a little less serious penalty. Now, just because it's a manslaughter doesn't mean you get off with it. I'll make sure you understand that. It just means that the penalty is less. The penalty is less. So when you look at any case, you have to try and apply the facts of that case to decide, is this murder? Is this manslaughter? What is it? And I want you to look at page 225 of your book and look at the case they provide. And let's go over this case. So it says, Ernest Martinez was at a party when he learned that his live-in girlfriend had gone home with another man. Martinez ran to his apartment, climbed in the bathroom window, and chased the two out the front door and into the streets. Obviously, he caught them in the act. Martinez managed to hit the man on the head several times with a shower curtain rod, and then cornered his girlfriend nude in the rear alley. He beat her savagely until a neighbor asked what was going on. Martinez replied he had caught her in the act. He then dragged her back into his apartment, turned up the stereo, and beat her to death. Martinez was jealous and often had warned the girlfriend about infidelity. Martinez contends he is guilty only of voluntary manslaughter because of the passion and rage he felt under the circumstances. Saying these are clearly emotional circumstances. So the question the book asks, how should the jury decide? So think about the facts of this case. So Martinez finds out that his girlfriend, who he's in love with, is with another man. He goes back to the apartment, crawls in the bathroom window, finds them in the act, chases them into the alley, starts beating her, is interrupted, stops beating her, explains that to the neighbor he caught them in the act, brings the girlfriend back to the apartment, puts up the stereo, and then kills her. Is this manslaughter? Or is this murder? Well, as you're thinking through this issue, let me read what the book says. And this turned out it was a real case out of California, if I remember correctly. And it says, Martinez was found guilty of murder in the first degree on two separate theories. First, there was evidence of premeditation. And secondly, his acts were murder by torture. They said the intervention of the neighbor, coupled with the act of turning up the stereo, deprived the defendant of that intensity of passion that alone could have sufficed to reduce murder to voluntary manslaughter. And they said what that means is there had been a cooling off period supporting the finding of malice. So in other words, if he probably had killed her right away, climbed in the window, sees them in bed, and then killed her, it probably would have been manslaughter. But what they're arguing from a legal perspective is that most states say if there's a cooling off period, you stop, you have time to consider what you're doing. And then he starts planning, well, I'm going to put the stereo up, bring her back to my apartment and kill her where no one can see it. That is no longer manslaughter. All right. Now the other terms we use when we talk about the issue of killing someone, it's not just murder, not just manslaughter, not just voluntary versus involuntary manslaughter, but the notions of vicarious murder and what some states have, which is called felony murder. So vicarious murder is when a number of individuals get together. They say, boy, we really hate so-and-so, and we want to kill them. So you got those three individuals conspiring to kill somebody. And then they say, hey, Joe, you're the best shot of the bunch, so we're going to make you shoot the person because we know you won't miss. The rest of us aren't as good with guns, but we'll be the lookouts. So Joe is the trigger man, shoots the person, and the question is what happens to his co-conspirators? Well, under modern law, criminal law, this is referred to as vicarious murder. And it basically says that anybody who conspires to a crime is guilty of that crime to the same extent as if they had committed it. So that's vicarious murder. A little different is something referred to as felony murder. Now, felony murder is any death that occurs during the commission of a significant felony. And it doesn't require, like these other forms of killing, it doesn't require the mental intent, the mens rea, the premeditation, the criminal state of mind. So it doesn't require the intent to kill. So maybe you have a situation where these three people, instead of wanting to kill someone, decide they want to rob a bank. So they go into the bank, they pull out a gun, but there's no bullets in the gun because they made it very clear, no, they didn't want anybody to get hurt when they developed this plan to rob the bank. And the bank teller sees the gun and dies of a heart attack. Well, according to most states that have felony murder, if anybody dies during the commission of a significant felony, and robbing a bank is a significant felony, they are all guilty of murder. So felony murder is one of the few types of killings that does not require the intent to kill anybody. And all the others, there has to be some kind of intent. Whether it's direct mental intent or your approach is so negligent that it leads to intent. So let's give an example that kind of relates to this. In terms of the intent issue and how it fits in with these ideas of manslaughter and voluntary and involuntary. Robert Watson, this is on page 227. Robert Watson. It says, Robert Watson, while intoxicated, ran a red light at high speed and narrowly missed hitting another car by skidding to a stop. He accelerated again at high speed and collided with a Toyota at another intersection, skidding 292 feet before coming to a stop. The driver of the Toyota and his 6-year-old daughter were killed. Watson's blood alcohol content indicated that he was intoxicated, and very intoxicated. He contended that he could be tried only for manslaughter because there was no proof of malice. He didn't intend to harm anyone. Is Watson correct? So think about that. He's intoxicated, he's driving at high speed down roads, almost killed one person, speeds up again, then does kill 2 people. Is this murder? Is this involuntary manslaughter? Is this vehicular homicide, which some states have? Well, in response to was Watson correct, the book says, no, he was not correct. Malice can be implied from any conduct that has a high probability of resulting in death, and when it is done in wanton disregard for human life. Watson was speeding through city streets while intoxicated, an act presenting great risk of death. He narrowly avoided one accident, only to cause another. These factors support a finding of implied malice. The jury verdict was guilty of murder. So again, when we talk about this idea of a mens rea, it's not just what you're thinking, but what your actions suggest. And what they're saying is this person's actions, Watson's actions, implied a total disregard for human life that anybody should understand could lead reasonably to people's deaths. You can't be driving at high speed down Main Street in Alliance at 70 miles an hour while intoxicated on Johnny Walker. All right, so those are the different causes of action against a person dealing with the killing of the individual. The next one we'll look at is this action of rape. Rape. And rape, the cause of action is sexual intercourse without consent and against the will of the victim. Now, when we talk about rape, there's also a subcategory of this that we have to mention, which is referred to as statutory rape. So statutory rape is sexual intercourse, but it's with consent. But the problem is, it's with the consent of a minor. So statutory rape is a crime, and it says that if you have sexual, even voluntary relationship with a minor, that from a legal perspective, the law has said that a minor cannot give informed consent. So statutory rape is one of the few crimes that doesn't require a criminal state of mind. And when you look at this, the book gives an example on page 228. And this is a true high visibility case. In this case, it was Mary Kay Letourneau. She was 35 years old and was a popular teacher in Seattle and the mother of 4 children. And she pleaded guilty to having sexual intercourse with a 13-year-old boy who was a student in her 6th grade class. The two originally met in her 2nd grade class. So I get this was a long romance. So according to the victim, they had exchanged rings and planned the pregnancy that produced their daughter. So now she's pregnant too. And the question is, was Letourneau guilty of rape? And the book says yes, she was guilty. It says Letourneau was sentenced to 7 years in prison. But the sentence was suspended after 6 months and she was granted probation. Promptly following her release from jail, Letourneau violated probation again by having sex with this victim, underage victim. With the probation violated, she was sent back to jail to finish serving her 7-year sentence, although she was pregnant. Her daughter Georgia was born that same month, and a book co-authored by her and her victim was published in Europe. So what you see is even consent, even getting married after the fact, those kinds of things, would not impede the government from bringing a suit in regard to this whole idea of statutory rape. Now there's also some other strange and interesting cases in regard to rape. So what if someone rapes someone and they know they have AIDS? What happens there? And on page 228 in the middle, they have an example of that. It says, Ignacio Perena kidnapped an 11-year-old boy in Florida, took him to a deserted warehouse and raped him. Perea had a clinical receipt in his pocket indicating that he had just tested positive for AIDS. What is he guilty of? Well, again, this was a real case. And a jury found Perea guilty of kidnapping, okay, so that was a felony, rape, and attempted murder. And this case represents the first time a jury considered the AIDS virus to be a deadly weapon. Other states, the book tells us, have created new specific crimes for those who engage in sexual contact while knowingly infected with AIDS. So it's interesting the kinds of things that can happen. All right, so we talked about murder, we talked about rape, we talked about manslaughter. Let's continue on with some of these other kinds of actions against individuals. And let's talk specifically about the idea of extortion and kidnapping. So extortion is obtaining money or property by wrongful use of force or fear against an individual. Force or fear. So the example they give you is that of Bill Cosby on page 229. And I said, Autumn Jackson demanded $40 million from Bill Cosby to keep secret his alleged parenthood, and then signed a $24 million payoff agreement that was negotiated in the FBI sting. Although Jackson's mother had a sexual liaison with Cosby approximately 9 months before the birth, Cosby patently was denied, paternity was denied and unproven, and the question became, is this still extortion? And I said, yes, it's extortion. He says, what Jackson believed is not relevant. Even if it's true, it doesn't matter. If you're trying to extort money from someone and threatening them with a certain action if they don't pay it, that in of itself is extortion, whether it's true, the allegation is true or not true. Kidnapping. Kidnapping. The use of force or threat of force in taking a person from one place to another against their will. Robbery. The taking of personal property from the person in the presence of another by force or fear. Now, we make a distinction between robbery and theft. There's a greater penalty for robbery than theft because theft is stealing from a person without direct confrontation. So when you have this direct confrontation, you do it in their presence rather than break into their house when they're not home, for example. The belief is that there's a greater possibility of violence. Now there's also an enhanced penalty if it's an armed robbery. So an armed robbery is any robbery that was committed with the use of a weapon. And many states have add-ons. So if you commit a robbery with a gun, some states have a 1-year add-on, some states have a 5-year add-on. Mayhem. This is where someone is wrongfully dismembered, disfigured, or maimed. Mayhem is again one of those crimes where specific intent to maim is not an element. That what you do is just so crazy and leads to so much damage that you're guilty by definition. So throwing a Coke bottle at your window of your speeding car and hitting someone in the face with it. Lorena Bobbitt was an example of mayhem. She actually cut her lover's personal area off and threw it out the window. Assault and battery. Now these are a little bit different. An assault is an unlawful attempt coupled with a present ability to commit a violent injury upon the person of another. So it's an attempt to commit a violent injury upon the person. It doesn't have to be completed. Now, a battery is if the assault is successful. So if you try to harm someone and then you do harm them, it is a battery. And that's why you always hear these terms together, assault and battery, assault and battery. Because there can be no battery without an assault. And you usually charge someone with both because the assault is a lesser included offense. So if you're going to try to do some plea bargaining, there might be an ability to charge someone with an assault if they plead guilty. All right, we're going to end here. The next time we talk, we'll talk very briefly about crimes against property, and then we're going to talk about criminal procedural law. Have a great day.